You remember, if you watched at all the first trial, or even just heard about the first trial, Michael Proctor really took a pivotal position in that trial as far as the defense was concerned. He became the villain that the defense was looking for. Will the defense have that same opportunity this time around? The defense now takes center stage in the high-profile retrial of a Massachusetts woman accused of killing her police officer boyfriend. Plus, several prosecution witnesses testified to the acts of control and violence they suffered at the hands of a music mogul. And a Wisconsin man stands trial for the murder and dismemberment of a woman he met on the night of their first date. All this and more this week on Courtroom Confidential. Lots of interesting developments on the cases that we are following closely this week. We are recording this episode on Friday, May 30th, 2025, and this is your Courtroom Confidential Weekly Roundup. Let's jump in. The prosecution rested Thursday in Karen Read's second trial after nearly a month of testimony from close to 40 witnesses focused on evidence from the scene and claims that Read repeatedly said, "I hit him," referring to Boston police officer John O'Keefe. Read is accused of backing her SUV into O'Keefe and leaving him to die in the snow outside another officer's home in January of 2022. Her defense argues that she was framed in a police cover-up and that someone inside the home killed him. Prosecutor Hank Brennan took a more streamlined approach, avoiding controversial witnesses from the first trial, including lead investigator Michael Proctor, who was fired in March for sending crude, sexist texts about Read. Brennan also left off the stand Brian Albert, the officer who owned the home where O'Keefe was found, and federal agent Brian Higgins, who had exchanged flirty texts with Read. Instead, prosecutors focused heavily on physical evidence and Read's media interviews, where she discussed how she drank and raised doubts about what happened. In one clip, Read told an interviewer, quote, "Could I have clipped him? Could I have tapped him in the knee and incapacitated him?" Adding, "He didn't look mortally wounded as far as I could see. Could I have done something that knocked him out and in his drunkenness and in the cold didn't come to again?" Prosecutors also pointed to Read's broken taillight, which they say shattered when she struck O'Keefe, and a broken cocktail glass O'Keefe was allegedly holding when he was struck. The final witness for the prosecution was Judson Welcher, a biomechanical engineer from Aperture. Over the course of 3 days, Welcher testified under intense questioning, ultimately concluding that John O'Keefe was struck by Karen Read's SUV. Read's defense kicked off Friday morning with Matthew DeSorga, an engineer at the motor vehicle accident reconstruction firm Delta V. DeSorga reviewed work completed by prosecution witness Shannon Burgess, a digital forensic expert who sought to reconcile discrepancies between data found in Read's SUV and O'Keefe's iPhone. DeSorga told jurors that his independent analysis showed the last lock event on O'Keefe's phone occurred after Read's car backed up. Read is facing charges of second-degree murder, manslaughter, and leaving the scene. If she is found guilty of the most serious charge of second-degree murder, she could spend the rest of her life in prison. What's happening here? Fair to say, this streamlined approach by the prosecution has made for a much stronger case. And I think that drives home the idea that not every witness needs to be called. Not every person who may be tangentially connected to a crime or a crime scene needs to be a witness in that trial. Just like with writers, the best writers are said to be the best editors. Part of being a smart trial attorney is not just in how you present the evidence, but in deciding what evidence, in fact, it is you're going to present. And that can be difficult. Sometimes it's hard to make edits. Sometimes it's hard to cut the fat. Sometimes it's hard to lose witnesses that you feel may be helpful in a small way, but could they perhaps be not all that helpful or perhaps even hurtful in larger ways. And making that decision is sometimes what makes for the best trial attorneys. There's a false premise that more is more. Sometimes less is more. Sometimes quality is more impactful than quantity. This is not a game of simply counting witnesses. That being said, some very significant witnesses were missing this time around in the prosecution's case, which begs the question, will they be called by the defense? First, we have Brian Albert. He is the now retired Boston police officer and the owner of 34 Fairview. Initially, he was called by the prosecution in the first trial, and the defense took great opportunities to cross-examine some of his actions that day, some of the telephone calls that he made that were described as butt dials, some of the failure to even leave his home when there were sirens outside, the idea that him as a police officer, a first responder, didn't do anything when he realized that somebody may be dead in his front lawn, somebody that he knew, a friend of his, and yet he still did not leave the house. These questions were used to great impact during cross-examination by the defense in the first trial, and it may have been some of the things that the jurors had questions with. Again, another witness not called this time around, Brian Higgins. He is the ATF agent. He was a friend of John O'Keefe's, and he had this flirtatious, perhaps blooming affair taking place with Karen Reed. We heard a lot of his text messages this second time around, but we didn't actually hear from the man himself. And again, the defense used his testimony to make, I think, great strides towards their overall theory about a conspiracy and a cover-up in this case. But the prosecution, I think, was wise in not doing this. The prosecution is saying, listen, our crime took place outside that home. Our crime scene is not inside that home. We are not concerned with who was inside that home, other than people to say John O'Keefe never entered that home, and they did put on witnesses to say that. So hearing from the homeowner doesn't really move the needle as far as the prosecution is concerned. Hearing from Brian Higgins, we saw his text messages, but hearing from him himself, that's not a suspect for the Commonwealth. That might be a suspect for the defense. Let the defense call them. In our case in chief, and this is the Commonwealth speaking, in our case in chief, the crime took place outside. It didn't involve anyone inside. And all of these other players are really just background noise. If the defense wants to call them, we invite them to go ahead and do it. But that all being said, the most significant absence in this entire retrial has been that the lead investigator, the now fired Trooper Michael Proctor, was never called. The excuses for why he wasn't called are a little bit more difficult for the Commonwealth to make. He is the lead investigator. He did recover evidence. He was the person quarterbacking this entire investigation. Why was he not called? Well, we know why he wasn't called. He wasn't called because he's now been terminated. And he's been terminated because of these vile text messages, in part because of these vile text messages that he sent in regards to Karen Reed. You remember, if you watched at all the first trial, or even just heard about the first trial, Michael Proctor really took a pivotal position in that trial as far as the defense was concerned. He became the villain that the defense was looking for. And they had him on the stand under grueling cross-examination for several days. That could have, again, been a difference maker with the jurors. And so let's talk about the decision by the prosecution not to call this person. What advantages did it give to the Commonwealth to not call Michael Proctor? Well, one, they're able to highlight and even argue to the jurors that Michael Proctor is not a necessary witness in all of this. They are able to prove their case without him. There were other investigators involved. There were other people involved. There's other ways that they're trying to prove their case, and all of it does not rise and fall with Michael Proctor as the defense would like you to believe. The other argument they could make is that little could have been done to mitigate the damage that Michael Proctor would cause to their case by calling him in their case in chief. And what I mean by that is, if they were going to call Michael Proctor, they're going to have to get into all those text messages. They don't want to suffer that same kind of example made of him the first time around. So they're probably going to talk about all of those text messages with him on the stand. Would that have mitigated the damage? Probably not. It probably still would have been the bloodbath that we saw the first time around. But I think more than anything, the Commonwealth is saying, listen, you want to muddy these waters, you want to cause this damage, well, then you're going to have to call this witness. And you're not going to have the advantages that you did on cross-examination. You're not going to be able to ask him the same type of leading questions. You're not going to be able to treat him like a hostile witness just because he's an adverse witness. There is a difference, by the way. Just because somebody doesn't favor your theory of the case does not make them hostile. As long as they're cooperating and answering questions, the judge is going to expect you to treat them as if they were a witness that you're calling and using the same rules of calling someone on direct. And there's this added idea that you cannot simply call a witness merely to impeach their character. In other words, you can't just call Michael Proctor and say, weren't you the lead investigator on this case? Yes, I was. Okay, let's talk about all the bad things you've ever done and all the bad things you've ever said. That's not the way it works. Now, the defense can say, well, listen, he is the lead investigator. He does have a reason to testify. We want to talk about his collection of evidence. And if along the way we get into his text messages, so be it. So we may very well still be hearing from Michael Proctor, but I don't think it will be as impactful as it was the first time around. But what do you guys think? Do you think the defense will call Michael Proctor, or is he more valuable to them as this boogeyman that never in fact takes the stand? Please let us know in the comments. The federal racketeering and sex trafficking trial of hip-hop mogul Sean Diddy Combs continued this week in New York with more emotional testimony. Combs is facing federal charges of racketeering, sex trafficking, and transportation to engage in prostitution. If convicted on all counts, he could face up to life in prison. Capricorn Clark, Combs' former personal assistant and creative director for Cassie Ventura, took the stand Tuesday. Clark testified that Combs controlled Ventura's professional decisions and image. She also described an incident where Combs showed up at her home with a gun, demanding they go kill rapper Kid Cudi after discovering Ventura's relationship with him. Clark told jurors she complied out of fear, but secretly called Ventura on a burner phone, warning her to keep Cudi away from Combs. Later this week, a witness identified only as Mia said she worked as Combs' personal assistant and was sexually assaulted by him multiple times. Mia described a volatile work environment where Combs alternated between praise and humiliation. In one incident, Combs slammed a bathroom door on her arm repeatedly after taking her phone and threatening to use anything incriminating he found against her. In a voice barely above a whisper, Mia testified that Combs sexually assaulted her on several occasions. She said Ventura was never present for the assaults and that she never told her. She said fear of retaliation kept her silent and that her past experiences with law enforcement made her feel reporting wasn't an option. She recalled one instance where LAPD officers pulled her over for speeding and let her go after Combs spoke to them on the phone. In another, she said police seemed starstruck when they realized Combs was in the vehicle. Mia told the jury, quote, "It's the most traumatizing, the worst thing that's ever happened to me." For years, she said she planned to take the assaults to her grave. Quote, "I was going to die with this," she said. "I didn't want anyone to know ever." Defense attorney Mark Agnifilo indicated on Thursday that prosecutors have notified his team of some changes to their direct case, which may impact the defense case and make it somewhat longer. Judge Subramanian has made it clear he wants the jury to begin deliberations around July 4th. What's happening here? RICO. Racketeering. We hear this come up every time this case is discussed. And it's very important to understand exactly what that law requires of prosecutors and how that's being applied in this case or not being applied in this case, or is the envelope on what RICO actually is being extended for this case or tested for this case. First of all, you have to show a pattern of criminal conduct. What do we have in this case? We have assaults, we have threats, we have breaking and entering, we have weapons possessions, we have kidnapping, we have firebombing, we have plenty of crimes. All of these are crimes, but they're not the crimes alleged in this case. Instead, they serve as predicate acts, as the underlying crimes to prove this overarching allegation here of a RICO violation. So you need crimes, a pattern of crimes. I think they've established that. But now you need those crimes to be taking part within the structure of a criminal enterprise, an organization, an entity. This needs to be something described as discrete, a recognizable structure. This is not just a random collection of individuals, okay? This has to be some sort of an organization. Something like we think of when we think of RICO cases and the mafia, an organization. You have a boss. You have different captains beneath him. Those captains also have other triggermen answering to them. There's a hierarchy. There's an organization. And they have a mission. What is the mission in this case? What is the organization? Okay, you could say, listen, he had associates, he had bodyguards, he had assistants, and all of them were kind of serving Sean Diddy Combs. But what is their mission here? When you're dealing with the mafia, it's the pursuit of power, it's the pursuit of money. But what are we talking about here? The pursuit of Sean Diddy Combs' sexual desires? Is that enough? Sure, the crimes were committed and others were involved, but were they all serving the same purpose of just satisfying his wants and desires? And is that enough? Sexual desires, jealousy, is this really what's contemplated by the RICO statute? One last thing on this. I'm not the only one questioning what the prosecution is putting on here. No one is questioning that Sean Diddy Combs appears to have been an absolute megalomaniac and acting without regard for anyone else for a very long time, doing what he wanted and getting away with it. Criminal acts all along the way. But many people are saying, all of that sounds awful, but how does that prove RICO? So I'm not different in all of that. But one thing I will say that you don't hear people talking about enough is, will the jury actually really be able to appreciate that distinction and care at the end of all of this? Will jurors be able to sit through weeks of people having trouble even testifying to the things that they've suffered at this man's hands, seeing how he's acted with impunity for so many years, and really get caught up in the weeds, as it were, of the RICO statute? Well, that's the defense's job, and that's exactly what they'll have to prove to them. But it is an interesting question to ask of how will these jurors let this man walk out the back door a free man simply because they're caught up in the details of a very convoluted statute? But what do you guys think? Do you think the defense will concentrate much of their case on this legal minutia and nuance, or do they have other battles to fight? Please let us know in the comments. Trial began this week for Wisconsin man Maxwell Anderson, accused in the alleged murder and dismemberment of 19-year-old Sade Robinson following their first date in April of 2024. Prosecutors say Anderson killed Robinson, torched her car, and attempted to cover his tracks by scattering her remains across multiple locations in the Milwaukee area. Anderson is charged with first-degree intentional homicide, mutilating a corpse, and arson, and faces life in prison if convicted. Robinson was reported missing after failing to show up to work. Her burned-out car was discovered the next day. Over the following weeks, her severed remains were recovered throughout the area. Data collection from Robinson's Life 360 account tracked her cell phone to various locations, including Anderson's residence and locations where her severed remains were found. Court records detailed text messages exchanged between the two before the date, as well as surveillance footage and eyewitness accounts allegedly placing Anderson at the scene where Robinson's car was set on fire. During opening statements Wednesday, prosecutor Ian Vance Curzon told jurors that Anderson tried to make Robinson disappear, walking them through a timeline from the pair's initial meeting to Anderson's allegedly disposing of her remains. Defense attorney Anthony Cotton said the state's case is filled with reasonable doubt and argued there was absolutely no reason for Anderson to have committed this crime. Quote, "We don't dispute any of that timeline, that they went out together and went back to Max's house, but that doesn't mean he killed her," Cotton told the jury. Turning to the state's theory that the killing took place in Anderson's home, Cotton said if that had been the case, there would have been a, quote, mountain of evidence to back that up. Finally, pointing out that no weapon or tool have been recovered connecting his client to the murder, Cotton added, quote, "They looked through his search history to see has he searched how to cut up a body, how to kill someone. No, absolutely not. No evidence of that." Trial is expected to last 2 weeks. What's happening here? This case is very sad, And it's tragic. And it is, I think, a strong case for the prosecution. It's a circumstantial case, but I think it's a strong case nonetheless. But something is missing from their case, at least from the defense perspective. There is no forensic evidence tying the defendant to the murder. And I think this case is a good example of a defense strategy that we commonly see in cases like this, where there is zero to little forensic evidence tying the defendant to the crime itself. There's plenty of circumstantial evidence that can be argued in this case, but there's little actual blood evidence, fingerprint evidence, DNA evidence, that kind of evidence that we all now expect to be found in every single case. An example, very similar to this, is the case of Bryan Kohberger. There was extensive searches done of Bryan Kohberger's vehicle and of his apartment, and they found zero evidence that he had ever been at that home or that any genetic material or blood was found from the victims inside of his car or inside of his apartment. Now, I'm putting aside some other evidence in the Bryan Kohberger case that I'm sure you're aware of, but this idea that how in the world could a crime like this took place? How in the world can you have a case where 4 people are stabbed to death, as in the case of Bryan Kohberger? Or how could you, in this case, have a woman dismembered and there not be any blood found in the apartment? There not be any blood found in the car? There not been any blood found on him? No DNA? We just have come to expect that. Where is the weapon? His defense asked. These tools that were used to commit this crime and dismember this poor woman, where are they? It reminds me of a legal axiom that I've said many times on this show, and I'll say many, many times again, and that is the absence of evidence is not evidence of absence. In other words, the lack of evidence of something occurring does not mean, one, that that evidence does not exist, could just be that you couldn't find it, and two, that you can therefore prove that the thing didn't happen. In other words, absence of a murder taking place inside of an apartment does not therefore mean the murder did not take place inside of the apartment. You could say, well, they just didn't find that evidence, or you could say that they cleaned up that evidence, but you cannot draw the absolute conclusion that means you can prove that thing did not take place. The absence of evidence is not evidence of absence. Here's the problem with that. As much as I can struggle to explain all of that to you, jurors are people, and people like common sense. And this type of a scenario strains our common sense. Jurors say to themselves, wait a minute, this would be a bloody scene. Wait a minute, dismembering someone is going to leave around a lot of genetic material, a lot of evidence, a lot of blood. I've seen TV shows. I've heard about cases that were tracked down using DNA. I expect that to take place here, especially if what the prosecution is saying is true and that this woman was killed inside of this man's apartment and dismembered there. Where's all the evidence? That doesn't make common sense to me. And it's going to be up to the prosecutors to explain to them that they cannot draw that conclusion just based upon the absence of evidence. But what do you guys think? Do you think the lack of physical evidence in this case will prove to be too large of an obstacle for the jury? Please let us know in the comments. Before we dive into the other cases making headlines this week, I'm going to ask one very small favor from you, and that is, if you haven't already, please take a moment to subscribe to this channel now. We want to continue to provide you with the highest quality content that we possibly can, and the best way we can do that is through your support. And please don't forget to check out Courtroom Confidential, the podcast. Please join our community on all major podcast platforms. Also making headlines, after 5 weeks of emotional testimony from accusers and other prosecution witnesses, the defense has begun presenting its case in the New York sex crimes retrial of a Hollywood mogul considered to be the central figure of the Me Too movement. Harvey Weinstein is due to decide in the coming days whether or not he will in fact testify, a move that could mark a dramatic shift from his original 2020 trial where he remained silent. That conviction was overturned last year by New York's highest court, prompting this retrial. Weinstein has maintained that all the alleged encounters were consensual. One of the first witnesses called by the defense was Helga Rose Samuelson, who shared an apartment with Kaya Sokola, one of Weinstein's accusers. Samuelson testified that in 2005, Weinstein had visited their apartment and had gone into a bedroom with Sokola. Samuelson said that Sokola never spoke to her about the visit. In the weeks prior, the defense has worked to cast doubt on the prosecution's narrative, often during brutal cross-examination aimed at raising doubts about the credibility and accuracy of what the jurors were hearing from prosecution witnesses. Weinstein is accused of raping one woman in 2013 and sexually assaulting two others in 2006, all of whom say he used promises of career advancement to lure and assault them. If Weinstein does not testify, closing arguments are expected to take place Tuesday. Nearly 10 years after a Kentucky woman vanished, the first trial connected to her presumed murder is now underway. Steve Lawson, one of three men charged in the murder of Crystal Rogers, is now being tried in Warren County after the proceedings were moved from Nelson County due to intense media coverage. Lawson is charged with conspiracy to commit murder and tampering with evidence. Rogers, a mother of five, vanished on July 3, 2015, leaving behind her vehicle on the side of the Bluegrass Parkway with her purse still inside. Prosecutors say Lawson's phone was tracked moving to where the car was abandoned and that he called Brooks Houck, Rogers' boyfriend at the time of her disappearance, around midnight to tell him the job was done. In their opening statements, Lawson's defense conceded his guilt to charges of tampering with evidence, saying he helped move the vehicle and even pulled the driver's seat up to make it look like Rogers drove to the parkway himself. But the defense maintains the involvement doesn't prove that Lawson conspired to kill Rogers. Judge Charles Sims III has barred all cameras and recording devices, including cell phones, from the courtroom, citing a circus-like atmosphere around the case, saying his goal is to preserve a fair and dignified trial. Steve Lawson faces 10 to 20 years in prison if convicted of conspiracy to commit murder and 1 to 5 years for tampering with physical evidence. Lawson's son, Joseph Lawson, and Brooks Houck are also facing charges and are scheduled for trial on June 24th. The infamously monikered Doomsday Mom's latest attempt to remove the judge assigned to her upcoming Arizona attempted murder trial was denied on Thursday. Lori Vallow Daybell filed a motion last week requesting a different judge, claiming that Judge Justin Boreski was biased against her due to his repeated denials of her motions. On Thursday morning, she appeared before a different judge for a last-minute oral argument on the issue. Prosecutors argued that Judge Boreski's rulings were legally sound and showed no evidence of bias. The new judge agreed, ruling that Vallow Daybell's disagreement with Boreski's decisions didn't prove judicial bias and denied the motion. Vallow Daybell is facing an attempted murder conspiracy charge in Gilbert, Arizona for allegedly plotting to kill her niece's ex-husband, Brandon Boudreaux. Investigators say in October of 2019, Vallow Daybell's brother, Alex Cox, shot at Boudreaux outside his home. Boudreaux was not injured, but a bullet shattered his car window while he was driving. This will be Vallow Daybell's third trial in recent years. In 2023, she was convicted in Idaho for the murders of her children, Tylee Ryan and JJ Vallow, and for conspiring in the death of Tammy Daybell, the first wife of her current husband, Chad Daybell. Chad was convicted in that case and sentenced to death. Just last month, Vallow Daybell was convicted in Maricopa County for conspiring to kill her former husband, Charles Vallow, in 2019. She represented herself in that trial and plans to do so again in this current case. Alex Cox, believed to be her co-conspirator in these cases, died before charges could be filed. Opening statements are scheduled to begin Monday. The armorer convicted in the 2021 shooting death of Rust film cinematographer Helena Hutchins was released from prison last Friday after serving just over a year of her 18-month sentence. According to the New Mexico Department of Corrections, Hannah Gutierrez Reed qualified for parole after completing 85% of her sentence, receiving credit for good behavior and finishing a drug rehab program. She is now back in Bullhead City, Arizona, while she'll serve out her parole until May of 2026 under strict conditions, including a ban on contacting Hutchins' family, curfew, employment requirements, electronic monitoring, and mental health assessments. Gutierrez-Reed was found guilty of involuntary manslaughter in March of 2024. The prosecution claimed the armorer was responsible for live rounds ending up on the Rust set. In a production under intense budget and time crunches, live rounds were found in actor and producer Alec Baldwin's 1880s Colt 45 replica that fired during rehearsals at the Bonanza Creek set, striking Hutchins and director Joel Souza. Alec Baldwin, also charged in the same incident, had his criminal case dismissed 4 days into trial last summer due to prosecutorial misconduct. Baldwin has since filed a civil rights lawsuit against the special prosecutors involved. A Massachusetts mother accused of killing her 3 children before attempting suicide appeared virtually in court as key pretrial issues were argued ahead of her February 2026 trial. Lindsay Clancy is facing 3 counts of murder for the strangulation deaths of her children, Cora, age 5, Dawson, 3, and Callan, 7 months old, who were allegedly killed with exercise bands in January of 2023. The Commonwealth has alleged that Clancy planned the murders of her kids while her husband, Patrick Clancy, was running errands. Her defense is pursuing an insanity plea, citing severe postpartum psychosis, and have filed a notice of lack of criminal responsibility. At Wednesday's hearing, the court addressed the Commonwealth's request for raw notes and audio recordings from The New Yorker, which interviewed Clancy's husband and others close to her. The defense welcomed the request, calling the comments favorable, while the judge acknowledged the complexity of invoking New York's Reporters Shield law and took the matter under advisement. A June 27th deadline was set for both parties to exchange records, and a status hearing was set for that date to discuss further proceedings. Clancy's trial was also pushed back by a month at the defense request, now set to begin February of 2026 with a final pretrial hearing in early January. Highly anticipated evidence suggesting an alternative suspect alleged by the defense in the University of Idaho student murders case has been sealed. This week, Judge Stephen Hippler granted Bryan Kohberger's defense team request to keep the filing and supporting exhibits under wraps, leaving the public in the dark about any possible alternate perpetrator theories. Kohberger is set to stand trial in August for the 2022 murders of Kaylee Gonzalez, Madison Mogen, Xana Kernodle, and Ethan Chapin, a case that rocked the college town of Moscow, Idaho, and drew national attention. The trial had been moved to Ada County, nearly 300 miles from where the crime took place in Lada County, placing a financial burden on the victims' families. 3 separate GoFundMe pages have been launched to help cover travel, lodging, food, and lost wages so the families can attend proceedings. The Idaho Crime Victims Compensation Program and the Idaho Prosecuting Attorneys Association do not provide funding to relatives of victims for travel expenses, according to the Idaho Statesman. Meanwhile, Judge Hippler has yet to rule on Kohberger's attorney's motion to postpone the trial start date based upon a leak of evidence featured in a recent Dateline NBC episode. You can find a link to the GoFundMe donations page for the families in the show notes of this episode. Before we get to what's on the docket for next week, I wanted to take a moment to thank you all for being a part of this beautiful, growing community. But I wanted to give a very special shout out to PDrink10 for their fantastic review on Apple Podcasts, as well as to our CC crew members, Hippie Mimi and Cancerfree09 for their support on YouTube. Please keep them coming. We absolutely love hearing from you. And please tell us where you are from. We are thrilled by the growth of our Courtroom Confidential community. On the docket for next week, Gregory Moore, the Ohio divorce attorney accused of killing his client, Cleveland Clinic nurse Eliza Sherman, more than a decade ago, will be back in court for a pretrial hearing on Wednesday, June 4th. 6 suspects in the deadly beating of Arizona teen Preston Lord will be back in court on Thursday, June 5th for a pretrial hearing. Lord was attacked and beaten to death by 7 teenagers at a Halloween party in Queen Creek in October of 2023. Victoria Goodwin, the Nevada mother who admitted to conspiring to kill her estranged husband, Ghost Adventurers star Aaron Goodwin, will be sentenced on Thursday, June 5th. She pled guilty last month to conspiracy to commit murder as part of her plea deal that saw a solicitation to commit murder charge dropped. Shanna Gardner and her estranged husband Mario Fernandez, who are accused of plotting to have her ex-husband Jared Britigan killed in 2022, will return to court on Friday, June 6th for a pretrial hearing. And finally, please join us on YouTube this Sunday for our special question and answer series, Sunday Funday. All are invited to leave us a voice message at thecourtroomconfidential.com, which we will answer during tomorrow's live stream at 9 a.m. Pacific, noon Eastern. That is it for us this week, folks. I am your host, Josh Ritter. You can find us on social media at CR Confidential on X, at The Courtroom Confidential on Instagram, or at thecourtroomconfidential.com. Thank you again for joining me. Have a great weekend, and I will see you again next week for another episode of Courtroom Confidential.